This is going to be a webinar about compliance with the FCC and FAA tower regulations. Steve Coran, I'm going to hand the mic over to him in a minute. Steve Coran is our DC counsel for WISPA. He is going to introduce our speaker, Kevin Kukler, and I'm going to go ahead and hand over the mic to Steve now. Steve, go ahead.
Well, good morning or good afternoon, depending on where you are. This is Steve Coran. I serve as WISPA's counsel here in Washington in proceedings before the FCC and other agencies. Pleased to be able to be here and to introduce my colleague Kevin Kukler. As Alex mentioned, the topic here today is compliance with FCC and FCC tower regulations. It's important for tower owners, lessees of towers, and buyers and sellers of WISP to understand how tower regulations can affect the value and the risk of what they are leasing, owning, or acquiring or selling. This is especially timely given the stepped-up enforcement by the FCC with big fines and some new developments in FCC regulations that we're going to talk about concerning co-location and other things. So let me introduce very quickly Kevin Kukler, who is counsel here at Lerman Center. He is a graduate of Emory University and a graduate of the George Washington University Law School. He is an expert on tower regulation issues regarding FAA and FCC rules, and he's the guy that I go to when, and other folks here go to when they have questions about tower regulations, tower registrations, enforcement, and other proceedings. So let me turn it over to Kevin Kukler, and he will take us through the rest of the webinar. Please, if you have questions, type them into the chat box. Alex will moderate those, and we should have time at the end for Alex to put some of those questions to Kevin. So Kevin Kukler.
All right, thank you, Steve, and thank you to Alex and WISPA for this opportunity to speak with you today about FCC and FAA tower regulations and compliance issues and how those may affect you. So, of course, this initial caveat at the beginning that this is intended to provide an overview of these regulations, and we're not getting into specific situations. Of course, though, if you do have questions, feel free to raise them at the end. But obviously, if you are dealing with a particular situation, you are strongly encouraged to consult with an attorney to discuss that specific questions that you may have. So here, I just want to provide an overview of the general topics that we will be discussing today. When we talk about FAA and FCC tower issues, we are talking generally about aeronautical studies by the FAA. They will look at the tower structures for impacts on air navigation and safety. And then it's FCC, so it's sort of a dual agency role here where the FAA will evaluate the impacts to the air, and then the FCC will be in charge of the registration, the marking, and the lighting requirements. And related to that, the FCC also has regulations that impose upon tower owners, but also on licensees that are co-located on a tower, certain obligations with respect to conducting environmental reviews, as well as potential impacts on historic properties. And then finally, we will touch on Section 6409A of the Spectrum Act, which, while it does not deal specifically with FCC or FAA compliance issues, it does deal with the relationship between federal and local state reviews of tower construction and modifications. And so it's certainly something that you should be aware of, and we'll raise that at the end as well. So starting off, why should you be concerned about these tower regulations? As Steve mentioned, the FCC has recently been very active in enforcement of these issues. So if you fail to comply with any of these obligations, you are facing possible sanctions for noncompliance, likely fines and forfeitures, In extreme cases, if you have a license for your transmitters, that could be in jeopardy. And you might also have to make some changes to your towers if there were any impacts on environmental or historic properties. So you might have to make some changes, and those could get very expensive. So here, there are some recent examples to highlight for you of some enforcement actions. In October, the FCC entered into a consent decree with a wireless carrier in Alaska. And that involved a situation where the carrier acquired another company. So it was an acquisition, buying and selling of companies. And as part of that, they acquired hundreds of towers that were owned by the company. And when they went and looked at it after they had acquired it, they found that there were over 100 towers or so that they had either failed to register, failed to get FAA studies, they were not properly lit. In some cases, they had not conducted the required environmental or historic reviews when those towers were constructed. And so the buyer in that case then became liable for these violations of the company that it acquired. Because they then were the owners of these assets. So they self-reported to the FCC in the situation once they discovered it, and that's something that you may want to consider when you're dealing with enforcement situations, because there were over 100 towers, and they likely could have been facing $1 million or upwards fines or forfeitures for these types of violations if the FCC had discovered them and brought the hammer down on them. So $620,000 in this situation was fairly reasonable and probably a good outcome for the company in this situation. But also wanted to highlight there that in addition to the fines, they had to then conduct a review and an inventory of all of their tower assets, and including not only the towers that they owned, but also any third-party towers that were owned by somebody else where they had antennas on it. And if those tower owners are not in compliance, they have to go to the FCC and report them if they don't make the necessary fixes. And there was also a more recent consent decree. That one was 2 towers where they failed to light it, and they had another tower which they had taken down, but they failed to notify the FCC. So that was just a paperwork thing for that one. But the fine ultimately was about $230,000. They did reduce it to about $3,000 because of the inability to pay. It was a mom-and-pop shop down in Florida. But that shows you the range of fines that you are likely facing. And then, of course, civil liability and litigation. If there is some type of aircraft accident and you did not properly light your tower, and there's loss of life, damages, those can be obviously very, very significant litigation issues that you're facing. But don't worry, now that we've scared you, we'll get into how to deal with these issues and how to make sure you're in compliance. As Steve mentioned, these regulations will touch upon obligations that apply not only to tower owners, but to lessees that are going on to towers. So here are some of the areas of concern. I just wanted to touch on those up front. If you are just leasing from a tower, what do you want to be concerned with? What do you want to be looking at? So first, has the tower owner, the party that built the tower, have they completed all of the requirements with regards to the FAA studies? If that's required, is the tower properly registered, marked, and lit? And the reason we'll get into that is because later on, under the FCC's rules, they will go first after the tower owner for violations, but if you have a license for your operations, you can be held secondarily liable. So you want to make sure up front if the tower is in compliance. In addition to that, you also want to make sure as to whether the tower owner has completed all the necessary environmental and historic preservation reviews. You yourself, if you have a license for your facilities, you have separate obligations apart from the tower owner to also complete historic preservation reviews. And we'll get into that later. In many situations, you likely may be exempt from having to do anything, but you at least have to make sure you've looked at that and have that in your records in case any issues come up. And if you're not exempt, you have to make sure that you've gone through that review. And as we touched upon just in the last slide, if you are going to be buying or selling any tower assets, any licenses, any antenna facilities, make sure you do your due diligence before the transaction, because if you're buying that, you will then face those liabilities once those transactions have closed and if those violations are discovered after the fact. And so related to that also, it's very important to check the language in your lease agreements because often those will have specific language and obligations that apply to tower owners, but also to lessees as to who is responsible for conducting these types of reviews, or it will require you as the lessee to make certain certifications or representations that what you are doing is in compliance with any applicable environmental or historic preservation requirements. And it may spell out indemnification requirements as well as to requiring you to indemnify the tower owner if there are any problems. So you want to look carefully at that language. So now we'll get into sort of the substance of what the different regulations are. So first, FAA Aeronautical Studies. These go to the tower owner, whoever owns the structure, and generally they must notify the FAA prior to construction in certain situations. So mainly if you are above 200 feet above ground level, or even if you're less than 200 feet but you're close to an airport, if you would exceed the imaginary slope near the airport runways. Obviously if you're constructing anything on the airport grounds, but also if you may be requested to notify the FAA depending on what type of frequencies you are using, or if you're near an FAA aeronautical facility. So there's various reasons why the FAA might want you to do that. Obviously you can have consultants who can help you determine that. The FAA also has a website where you can go in and enter your basic tower information, and it will tell you whether or not you need to notify them. There are some exceptions, but those are very specific. If you're shielded by existing structures, you may be exempt. And then if it's 20 feet or less in height, except if you are increasing the height for another antenna structure. So if you're just putting up a 10-foot pole or something like that, that's 20 feet or less on the ground, you generally then don't need to notify it. But again, it's case by case, so I would encourage you to, if you have any questions, to look specifically at that, or consult with your management or in-house counsel or someone to see whether or not it requires that review. The process is then you notify the FAA. They take generally anywhere from 45 to 60 days or so to evaluate that structure, and then likely at the end of that they will come out and issue you a determination of no hazard, which says they've looked at your structure, it's not going to be a hazard to air navigation. They may recommend that you light the tower or mark the tower painting. They may require you to come back and notify them once you finish construction, and those determinations are generally valid for about 18 months. And you can get extensions on that if you have not yet started construction within that time frame. So that's sort of step one of that process. Once you've gone and got that FAA, like I said, they will come out and recommend marking or lighting. I wanted to point out that recently, back in December, they adopted a new advisory circular, and the circulars are set, those are the documents that set forth the FAA's standards and guidelines for marking and lighting of towers. So a couple things I wanted to point out is, one, that they revised it for what towers are considered obstructions. I think before it said 500 feet, they clarified it now that it's 499 and above, because they want to make sure that if it's anything that's within that range, that's looked at. They also made some changes to the lighting recommendations, mainly the purpose of which was to get tower owners to change the lighting that they have on towers to reduce the effects on migratory birds. And FAA and Forest Service and all the different federal agencies have looked at this and determined that certain types of lighting is less likely to cause migratory bird deaths, and that birds are attracted to certain types of lighting. So generally they want you to use the flashing lights instead of the steady burning lights. So they made some changes in that regard. Once you then get your FAA determination, if you then are going to be hosting FCC licensed facilities, you have to go and register that with the FCC. In certain cases, you may also register it because of environmental reviews. So you can voluntarily register it even if it's not required. But the FCC requires you that if you have to notify the FAA because of physical obstruction, then you then have to go and get an ASR from the FCC. And that entails a two-part process. So step one is you go online to the FCC's website and you submit what's called the FCC Form 854, get that partially completed. You basically just put in your coordinates, your tower height, who owns the tower, and what's called the national notice date, which is the date that you want the FCC to put up a notice on its website. And we'll get into that in a minute. But once you've completed that process, then you do step two, which is once you've gotten your FAA determination, you put in your study number, you certify that you provided a local notice, and you certify that you have completed the environmental review and that the tower will not have a significant environmental impact. And then once you've gotten your ASR, you then have to notify the FCC within 5 days of actually constructing the tower. So the ASR environmental notice period is something that's relatively new within the past couple of years. The FCC had to adopt this in response to some court cases where environmental groups challenged that the FCC was not providing adequate notice of towers and not providing them with the ability to weigh in on whether or not these towers were causing adverse environmental impacts. So basically what the FCC said is for any new tower that you have to register, and in some cases if you are making changes to an existing tower, the marking or lighting on the tower, you have to go through this environmental notice period. So after you've done step one of your ASR form, you then have to go and publish a local notice in a newspaper or through some other means. And then after that date, the FCC will put up a notice on its website for 30 days. And during that time, anyone can come into the FCC and raise concerns about any potential environmental impacts that might occur as a result of the tower. The FCC will then review any comments that are filed and determine if any further environmental review is required. If no environmental review is required, if no one files any comments, then the FCC will grant your ASR application and they will give you your registration, authorizing you to move forward. There are some exceptions to the ASR environmental notice requirement, which are listed here. But again, this is sort of a broad overview, and so you do have to look at the specifics of what you're doing. But generally, you're allowed to, for example, lower the height of a tower or do small increases less than 10%. You can change, remove the lighting, or you can change to a more or equally preferred lighting. And the FAA has ranked their lighting systems from most preferred to least preferred, which generally takes into account how is this going to affect, like, for example, the migratory birds and things like that. And so if you are going to go from one type of lighting to another, in some cases you might have to notify the public, other cases it's okay. But again, the caveat there is just you should really look at the rules to determine whether or not the notice is required or not, because there have been enforcement cases as well at the FCC where parties did not properly go through the notice or did it after the fact and got in trouble. As the tower owner, then this also applies to you. What do you have to do once you've gotten that ASR? You then have to post that number on a sign at the tower, and highlighted in bold is the specific language from the regs as to where it needs to be visible. And so mainly it needs to be visible where anybody from the public who is going to look at it, mainly FCC inspection agents, because they drive around. This is sort of low-hanging fruit for them, where they will go around, look at ASRs in their database, and then drive out to sites to see, have you posted the number? And so it needs to be, for example, on a fence or somewhere where they could reach it. You also have to provide a copy of that number to any tenants that you have on the tower. You can either email it to them or send it to them by hard copy. If you, going in the future then, once you've gone through this process, you've built the tower, you've done all the registrations, if you want to make any changes to that tower, in many cases, you will have to go through that process all over again. You'll have to go and notify the FAA. For example, if you are making any changes or corrections to a tower of 1 foot or greater in height, or the coordinates for 1 second or greater, any of those changes, those require prior approval from the FAA and the FCC. So you have to go and file your notices all over again, and in many cases, you might have to go through that environmental notice requirement as well. And specifically, in addition to that, any changes in marking or lighting will also require prior approval. So the FAA tells you you can put up one type of lighting, and you want to change that, you've got to go to them and as well to the FCC. Also, if you make any changes to the height, then you have to notify the FCC within 5 days. If you take down a tower or if you sell a tower, the new owner has to notify the FCC within 5 days. And that was one of the examples of the enforcement case from earlier. In general, how do the FCC's rules work? So, as I sort of mentioned, it's a dual agency role. The FAA will recommend the lighting, but the FAA doesn't actually have any enforcement authority. So if you are not in compliance, it's the FCC that's going to come after you, not the FAA. So the FCC recently updated its rules where they will require you, though, to conform to the FAA's recommendations. So when the FCC issues you the ASR, they'll say you have to light this tower per the FAA, and they will list the specific lighting requirements. As I mentioned, the FCC's rules and the way that they operate from an enforcement standpoint is that they will primarily look to the tower owner for compliance, and any FCC enforcement action will be directed towards the tower owner. However, if you are a non-owner of the tower, but you are a licensee or a permittee on the tower, and you are aware that the tower is not being properly maintained in accordance with those requirements, or if you're generally aware that the tower owner is not acting in accordance with the FCC's requirements, you have an obligation under the FCC's rules to take reasonable steps to bring that tower into compliance. And that generally means that you should notify the tower owner, notify the FCC, notify the FAA, but first, obviously, you should go to the tower owner and try to get them to make any changes before you start going off and bringing up blowing the whistle. So, but if you don't do those steps, the FCC could come after you, and they might look at, depending on how severe is the violation, how long did you know about it, what, if anything, did you do about it. So that's an important point to keep in mind. And then finally, you can't highlight enough that no changes to the lighting or marking may be made without prior approval. So a lot of times companies will get into trouble because they got lighting approved, they put it up on there, and then 10 or 15 years later, they made some changes and they realized they never notified the FCC or FAA. The tower owner also has to make sure that they are inspecting that tower to make sure that the tower is properly lit and marked. So these are FCC rules that apply in these situations. So first, the tower owner has to observe the lights every 24 hours, either visually by going out to the tower themselves or by using automatic indicators and electronic systems that monitor those towers. If you don't do that, you have to have what's called an automatic alarm system that is designed to not only detect a lighting failure, but then will notify the tower owner whenever there is a lighting outage. In addition to that, you also, as a tower owner, have to inspect that tower and inspect your mechanical devices, any alarm systems that you have every 3 months to make sure that those are properly working. The FCC has granted waivers to that second requirement that you have to go out and look at your alarm systems every 3 months, but you have to use certain types of systems that have already been approved. And that's, again, on a case-by-case basis. You have to petition the FCC, and you can get approval. But they've already granted waivers to, like, American Tower and to a lot of companies that own towers, and that saves them, it can save you a lot of money, because obviously if you have hundreds of towers, it's very expensive to go out every 3 months and look at all of your towers. In addition to those requirements, if you have any outages on these towers, you have to notify the FAA whenever the lights go out, if it's a top steady burning light at the top of the tower, or if you have a flashing light wherever it is on the tower and it lasts more than 30 minutes. You have to then notify the FAA, tell them when you intend to return to service, tell them what you're doing to fix it, and if you can't get it fixed within that time period, you have to keep going back to the FAA and alerting them. In addition, you have to keep records of that, any lightning outages, for a period of 2 years, of when the lightning outage occurred, when did you notify the FAA, when did you repair it. And this comes into play, as I said on the first slide, if there is any aircraft accident where the tower was not properly lit or fixed within a reasonable time, and you did not keep these records, and you did not comply with these requirements, that will come back to hurt you in litigation, because then that can be used to show that you were not in compliance and that you were negligent, and that you may be liable in result of any accident. Under the FCC's rules, you generally have to repair any lighting outages as soon as practicable. And that is sort of a very vague, broad, open-ended standard. There's no specific time periods, but the FCC will just generally look at whether you exercised due diligence and made a good faith effort to repair the lights. Did you take all efforts that were within your control to do so? And if you did not, then you could be held liable by the FCC for violating those rules, and you will face fines or forfeitures. If there's any painting on the tower, that has to be cleaned or repainted as often as needed to maintain good visibility. And the FAA has a chart that you can use. Basically, you take that chart out to your tower, and you hold that up next to the tower, and you see whether or not the painting matches up. So that covered sort of the first 2 points that we talked about in our overview, the FAA Aeronautical Studies and the FCC antenna structure registration, marking, and lighting requirements. Like I said, those generally apply to the tower owner, but the tower lessee can be held secondarily liable if you are aware of those violations and you did not take reasonable steps to bring the tower into compliance. So next, we're going to talk about the FCC's environmental and historic preservation reviews. And why does the FCC get involved in environmental issues? They're not the EPA, they're not Forest Service, they're not Fish and Wildlife. But under general environmental laws, which you may have heard of, such as the National Environmental Policy Act and the Historic Preservation Act, federal agencies such as the FCC are responsible for ensuring that their actions do not have any adverse effects on the environment. And so, as far as the FCC is involved, there's 2 things that are deemed quote-unquote federal undertakings under these environmental rules. And the first is its ASR program. So if you have to register a tower, or if you have to get an FCC license, in that case, those 2 things trigger these requirements. And so the FCC then imposes duties on you as a tower owner who is registering a structure, or as a licensee who is getting a license, to comply with these. So it said who needs to comply. 1 is the ASR applicants, 2 FCC licensees, and that's both site-specific licenses, fixed point-to-point microwave, or you may have a general geographic area license which says you can operate anywhere within this area, but you don't have to register or license your specific sites, but you still have to comply with the environmental rules. And in certain cases, if you're a licensee, like I said, before you put up a licensed transmitter, you also have to comply. So, Steve, did you want to add something? No? Okay. So that's generally, but again, case by case, if you have any questions, you need to look at that as to whether or not what you're doing triggers any of these requirements. So here's the FCC Environmental Checklist, which generally applies, if you are building a tower or you're co-locating a licensed facility onto a transmitter. When you file your ASR application for the tower owner, or when you file your FCC Form 601, which is your wireless application, there are specific questions on there where you as the applicant are certifying that an FCC grant of the ASR or an FCC grant of your license will not cause an adverse effect on the environment. And those questions you have to answer under penalty of perjury, and you are facing separate significant fines and forfeitures or other penalties if you mislead the FCC. So if you haven't done those requirements, but you answer no, and then it turns out you didn't complete it, you're facing liability from the FCC. So the FCC has said generally that anything in these general areas are considered environmentally sensitive, and we need to look at these. So if you're building a tower in a wilderness area, in an area where you're going to affect threatened or endangered species or their habitats, if you're in a floodplain, if you're going to affect historic sites, including Indian, religious, or cultural sites, if you're going to be putting up high-intensity white lights in residential neighborhoods, that can require an environmental assessment. You also have to look at the RF exposure limits for certain licenses, and in certain cases you may need to conduct an environmental assessment for that. And then also anything over 450 feet you have to look at for impacts on migratory birds. So those areas you want to try to generally avoid if you can, because then you can limit any type of environmental review. It doesn't mean that you can't put up any towers in these areas, but it's going to be a lot more expensive and a lengthy process to complete all of the environmental reviews. The FCC encourages tower owners and licensees to avoid those areas by exempting anything outside of those environmentally sensitive areas from review. And again, it's upon you as the licensee applicant or the tower owner to you check your box on your application that you're not going to be in any of those areas. So they're trusting you that you've done this review. They've adopted some additional exclusions. One recently, for example, is if you are going to be doing anything in a right-of-way that's been designated by a federal or state government for communications towers or utility lines, you can put up facilities in those areas, including new poles, without having to undergo those environmental review. But again, there are specific caveats to that, the main one being you can't go up more than 10% higher than existing structures in that right-of-way. Also, this mainly apply, like I said, to if you're putting up new towers. If you're co-locating on any existing man-made structure, which includes a tower, a building, grain silos, anything like that, you are generally exempt from the environmental review. You may still have to complete the historic property review and the RF evaluations, but you don't have to worry about any impacts on, like I said, the endangered species or floodplains or anything like that if you were just co-locating. The historic preservation review. Now, what does that entail and what does that mean? So, like I said, if you are going to be co-locating or constructing a tower in an area where you could have impacts on historic properties, you may have to do some environmental assessments. And so the FCC has adopted certain agreements that specify what steps you have to take to determine that. So the first agreement they have applies to collocations. So if you are going to be putting up an antenna onto an existing structure. So that applies to FCC licensees going onto existing towers or other non-tower structures. And then later in 2005, the FCC also adopted what's called the NPA, the Nationwide Programmatic Agreement, which applies to any new towers or any co-locations that are not otherwise exempt under the first agreement. And there are a lot of specific definitions, a lot of specific things that you have to look at to determine whether or not you have to undergo these historic preservation reviews. But one thing I want to point out is that what do they define as a tower? And that is generally any structure that is built for the sole or primary purpose of supporting FCC licensed antennas. And so if you fit within that category, that is considered a tower as opposed to a utility pole or a building or some other structure which can house antennas but is not built primarily for that purpose. Because there's distinctions under these agreements as to what reviews you may be required to do and whether or not you're exempt. So it depends in part on what type of structure you are going on to. So generally, you can mostly co-locate on existing towers unless there's 4 limited situations where it's not otherwise exempt. So first, if you're going onto a tower, you have to look at when was the tower built. And if it was before 2001, you're generally okay as long as the tower is not subject to any pending review and you can meet these other requirements. The important thing here is that if the tower itself was built after March of 2001, which is when the collocation agreement was adopted by the FCC, if that tower owner has not completed the reviews, then generally you cannot collocate on that tower without going through some additional steps. Like I said, in addition to when the tower is built, you have to look at whether or not that will result in a substantial increase in size of the tower. Are you going to raise the height of the tower by more than 10%, or the width by a certain factor? Are you going to be putting up more equipment on the tower? You have to look at that. Also, has the tower itself, as the owner, have they received any complaints, or has the FCC looked at this? So generally, as long as you are meeting these requirements, you can go on that tower without having to undergo any type of historic review. I won't get into too much detail, but there's also some additional things you need to look at if you're going to be putting up an FCC licensed antenna onto a building or other non-tower structure. Those are often, you can do that without having to undergo review, but you have to look in part the age of the structure, and I think under the FCC's rules, it depends on whether or not the underlying structure is 45 years old or older. So if it is, it's not exempt, and you might have to undergo a review because they're concerned that something like that might be historic. And it also depends on the location of the structure. Are you near any historic properties? So you do have to look at certain things, but generally you can be exempt. There's also an additional exemption for co-locations on utility structures, and that's defined as utility transmission or distribution lines, where otherwise required solely because the utility pole is over 45 years old and you don't meet the first exemption. In that case, you can still go onto that utility pole without undergoing review, look at certain other factors, but it's much more streamlined. And then here's sort of the other broad range of exemptions under the NPA. Replacement towers, so if you're taking down a tower and you're putting up a new tower, as long as it's at that same location. If you're putting up towers in certain locations, such as industrial parks or rights-of-ways, a lot of times in those cases you may be exempt. But the caveat here is that there are specific definitions and limitations on those exemptions. So you do have to look carefully at those to ensure that you qualify for those exemptions. And the FCC generally recommends that that evaluation be done by a manager at your company or an attorney at your company, or somebody who understands the environmental and historic preservation rules and can make a determination. So if you've gone through that process and you determine at the end that you are not exempt and you do have to undergo review, what's required? So generally you have to look at your area of potential effects from both a visual and a physical standpoint, and then you have to hire an environmental consultant to go out into the field, do some studies, look at what historic properties, if any, are there, and what might be the impact, and then you prepare a report with that. You submit that to your state historic preservation review officer for a 30-day review period. Depending on what the findings are, there might be an additional review period where it has to go to the FCC. In addition, as part of the process, you have to notify the local government agency that has jurisdiction over the land where you are constructing the tower, and you also have to publish a local newspaper notice as well. The most time-consuming aspect of this is the TCNS process of notifying Native American tribes. The FCC has a website where you can go on, you enter your tower information, and then it will give you a list of all the tribes that want to be notified. And this process can take anywhere from 60 to 90 days because you have to do multiple notices to the tribes. And a lot of times the tribes want to send somebody out there to monitor your tower construction. They will want to be paid a consulting fee, which can range from hundreds to thousands of dollars. And once they've expressed an interest, you can't construct until they sign off on the project because they are considered a sovereign governments that have rights under treaties with the United States government, and the FCC takes that very seriously and is very sensitive to that. And tribes can express an interest anywhere throughout the country. So even if it is a tribe that has a reservation in Washington State, but you are located in Tennessee or Kentucky or DC, and you are building a tower there, that tribe has the right to assert an interest in your tower project. And the reason being is that because at one point they may have lived in that area, or they may have been forced to migrate through that area at one point, and they may have attached some significance to that area. So don't assume that you're dealing with only tribes in your state. It could be anywhere in the country, and it can be a very lengthy process. So watch out for that.
I actually ran into that once with a new tower that was being built on tribal lands, and the tribe had somebody at the site all the time that they were working on the tower, just sort of watching. I don't know if they paid them a fee or anything, but what Kevin said is right. They, the tribes may take an interest in seeing what you're doing, or disturbing any burial grounds, or moving a rock the wrong way. So important to know.
Yeah, like I said, the FCC is very deferential to that, because I've worked on a number of projects for companies that were putting up towers, and they had environmental consultants and archaeological consultants who looked at it and said this tribe really has no ties to this area, and we questioned whether or not they really have an interest, but the FCC said all the tribe has to do is say that they're interested, and that triggers your obligation to consult with them. So like I said, that process can be very lengthy. It can take like 60 to 90 days for the tribes alone, and oftentimes can take longer. So you need to build that into overall timeline and get that process started as early as possible. And like I said, that can apply not only to tower owners, but also to FCC licensees. If you're co-locating on a tower and you're not otherwise exempt, you might also have to notify the tribes. So I also wanted to touch on some obligations that apply to the tower owners, also to FCC licensees that are going on to towers, and this is something that a lot of times will also be in your lease agreements that you need to look at very carefully, because the FCC has limits regarding how members of the public can be exposed, as opposed to also workers that may be going onto the tower, or rooftop facilities, how much they can be exposed to radio frequency radiation. So I won't get into too much details, because we could probably do a whole webinar just on this alone, but generally there's two different types of limits. One, like I said, is general population, and then there's a separate limit for the occupational or controlled exposure. And they look at, depending upon on how secure is the facility, who has access to it, what type of training do you need to get access to it, are you generally aware that there's RF radiation, is there signage alerting the public or a worker that they may be exposed to RF radiation, and are they taking proper precautions? The FCC, from an enforcement standpoint, will look at the owners of the tower as well as the licensees. If there are multiple licensees on the site, they will look at all of the licensees jointly to determine who may be responsible. So you need to be aware of what the RF rules are and what your obligations are. So we encourage you to look at that. There is a pending rulemaking that the FCC is looking at adopting specific rules on signage, and that's been pending for a while. But I know the FCC has talked that they may be coming out this year, or they are looking at doing that. So they look generally right now to various guidelines and industry standards. There's a bulletin, OET bulletin from the FCC 65, which recommends uses of signage that complies with the IEEE standards. There have been a number of consent decrees dealing with this issue. This slide references one from November, where this was against, I think, T-Mobile and another Sprint. Was it Sprint? Okay, and another licensee, where they had their antennas up on rooftops, and the building owner complained that they were not being in compliance because they had its workers up there, and the FCC went and looked at it, and there were a number of violations there, and so they got fined thousands of dollars. And one of the things specifically that the FCC fined them for was the fact that they either didn't have signs or notices warning the workers or the employees in the building that if they were on the rooftop that they could be exposed to RF radiation. They didn't have signs that properly marked where on the rooftop they could be exposed or what the limits were. or the signs were generally worn or faded and just did not provide proper notice. So that's one thing. As a tower owner or as a licensee, you want to make sure that there is proper signage that alerts either the public or tower owners as to what those requirements are.
So before we go to the last section, one thing I just wanted to kind of bring together here is that note that in November and December, the FCC entered into these 3 consent decrees, one on RF signage and the other 2 on other tower violations. And it sort of suggested to us that this was something that the FCC was definitely interested in, and that we should convey to you kind of the stepped up enforcement, and maybe suggest that you know, if you have a lot of towers, whether you own them or lease them or want to build new ones or are acquiring systems, it might be a good idea and a good opportunity to, you know, audit what you have and to do sort of a compliance review to make sure that you're checking all the boxes here, because my sense is that the FCC was trying to send a message, and by entering into these consent decrees, and you know, if a field inspector happens to be in your area, or if somebody turns you in, or some of these other circumstances where, you know, a building owner might suggest that the signage isn't right, or it's self-reported from a transaction. I mean, these are things that you can try to avoid, or at least mitigate any damage if it's out there. So I just wanted to kind of mention that you know, now's maybe a New Year's resolution might be to you know, to take stock of your tower assets and think about ways where you can avoid some big penalties and paying lawyers a lot of money to get you out of a jam. So just wanted to kind of bring that to a head before we kind of touch the last subject, which really isn't compliance so much, but there's been a lot of chatter, I know, on the WISPA list recently about collocation and about dealing with zoning authorities that may not be fully educated on some of the things that were in the Spectrum Act. And by the way, some of the streamlining that took place with historic preservation review and environmental review, those took place back when the FCC adopted rules implementing what we call Section 6409 of the Spectrum Act, which deals with getting approvals to use tower assets. So I think, Kevin, that's our last topic, so roll away.
Yeah. So I'm sure at this point most of you, if not all of you, are familiar already with the Spectrum Act, but here we just want to lay out, you know, what are we talking about. You know, as Steve mentioned, this was you know, around that time when the FCC was also looking at its rules, and Congress came in and recognized that the process of dealing with state and local governments was, you know, taking too long and was not uniform throughout jurisdictions. And so in an attempt to resolve that, they you know, impose certain requirements where state and local governments have to approve certain types of collocation requests. And this first bullet point is the language from the Act, and I've highlighted in bold here some of the key phrases and terms from the Act. You know, generally they have to approve, like I said, its requests for collocations of transmission equipment on a wireless tower or a base station, so long as that does not substantially change the dimensions of the tower. And if you qualify, if you meet within those requirements, the state or locality has to approve your application within 60 days, and there's certain exceptions. Don't do so, the application is then deemed granted, which means you can then, I believe, Steve, you can go to court, right, to get the court to say, we now have authority to go ahead and construct. And there are certain processes that you have to go through. But you know, we've been dealing, I know Steve has been dealing a lot with questions that have come up from WISPs, and I've been dealing with these questions as well for other types of FCC licensees, where the localities either have recently adopted ordinances or are going through the process of revising their ordinances to reflect this, or perhaps they have not, and they are still imposing requirements that contradict or conflict with this federal law. And so in certain cases, you then have to go and educate them to say that there's this new federal law that may apply, and here's why it does apply, and here's why they do have to approve it. So here are some of the key terms from that act. What is a tower? What is a base station? What are you putting your facilities on there? So a tower is generally anything that supports FCC licensed facilities. So that lattice towers, guide towers, anything was built for that purpose is a tower under the act. But anything that is for example, a building or a grain silo or anything that wasn't built for that purpose is considered a base station if, at the time that you submit your application to the state or local government, if that building already has an antenna on it that underwent the applicable review, and there's some other requirements, but basically that's the main thrust of it. In that case, it's a base station, and it qualifies for the Collocation Spectrum Act review, and they then have to approve it under those requirements. So, for example, if you've got a school or something like that where they've got antennas up on there and you're putting up facilities for, provide broadband to the schools or to the community, if they've already got antennas up on there, it may qualify as the base station and may qualify under the act. Again, you have to look at it on a case-by-case, but that's something to consider. And then transmission equipment is anything that is used for licensed or authorized communications services. So that includes unlicensed devices as well under the FCC's rules. So that includes, I think that was something that WISPA worked very heavily on in terms of getting that into the language and supporting that at the FCC and in other places. So I think that includes the equipment that WISPs use as well.
Yeah, as much as we sometimes like to bash the FCC, these were very pro-business and pro-wireless, fixed, mobile, what have you, rules that the FCC implemented as a result of the act. And the Fourth Circuit down in Richmond about a month ago heard an appeal from a bunch of counties and local municipalities, a case called Montgomery County, Maryland versus FCC, and the court didn't have any problem in saying the FCC was within its discretion to adopt these definitions and the rules it did. And I saw yesterday that they had asked for a rehearing. That's not likely to be successful, given that it was a pretty, reading the court's decision, it looked like they didn't have much trouble upholding the FCC rules. So just want to mention that so that you understand that these are rules that WISPA fought for. Kevin and I both worked on the comments and reply comments. There were a lot of other associations lined up on one side, and you really had the municipalities and counties on the other side, and they really don't like this. PCIA has generated some documents that are designed to sort of give model ordinances and checklists for compliance, but the key thing here is the 60-day deemed granted provision, and also these broad definitions of tower, base station, and transmission equipment.
And so that sort of wraps up our presentation for today. The last slide just talks about some of the steps that we encourage you, and Steve kind of already talked about some of them, and we talked about some of them earlier, but conducting inventory of your assets, making sure that you do due diligence before any mergers or acquisitions, but also looking at your company policies and procedures that you may have in place, and if necessary, updating those to make sure that any new towers or collocations are in compliance, and looking at your agreements. Also conducting training on an annual or other regular basis to any of your employees that are involved in the tower collocation construction to look at these so that they are familiar. And because those are really at the front line is people on the field that are going through these projects so that they understand the requirements and can raise those with management or council if there are any red flags or questions. So I think with that, hopefully we have some time for questions now.
Alex, questions?
Yeah, we've got some questions here. The first one, somebody has a client who wants to install a tower that does not require the lighting, but they want to put it on there anyhow. And so his question is, does he need to do anything with the FCC about this lit tower, even though doesn't meet the requirements for having lights on it?
So, the FAA, first you need to look at what the FAA, advisory circulars are, because they do have like those standards which, recommend the different guidelines and standards for lighting towers, and you may voluntarily light towers as long as you are in, compliance with those guidelines. I believe in the FAA advisory circular, it does say that you should go to the FAA first if you are planning on putting up lighting on the tower, so that they can look at it to make sure that it does not, will not have any adverse impact on air navigation. And then, depending on whether or not you need to, you need to register that tower with the FCC, you should also then generally notify the FCC that there is lighting on the tower, and that it was done so voluntarily. Because I've worked on a couple of towers for clients where it did not have to be, the FAA did not recommend any marking or lighting, but they did put up lighting either because it was required, I think perhaps by like their state Department of Transportation, I think, or there was a local hospital nearby that had a helipad and they wanted them to put up some lighting on there, and so they did voluntarily do that. But in those situations they did notify the FAA to make sure the FAA was aware of that and didn't have any problems, and they did make sure that the FCC was notified so that it was reflected on their ASRs that the tower was voluntarily lit.
All right, the next question is, at what height do you have to have lights on a tower?
So again, it's case by case, but I think under the FAA's recommendations, typically anything over 200 feet usually always has to have some type of lighting. But again, the FAA will evaluate it and they will come and recommend whether or not lighting, has to be put on it. But I think generally anything over 200 feet usually always has to have lighting on it. But something could be under 200 feet and might still require lighting because it might be near an airport or near a runway, or because of what else is around it. So it's really depends on, I think, a case by case, but generally 200 feet.
So Kevin, does the FAA also look at sort of private airfields that may not be sort of federal airports? Do they have that in their database, or is there a separate state regulatory process for sort of smaller airports that might be in rural?
Yeah, I think, there's, like I said, we are covering here, George, generally, again, I meant to say that as well, too, is that these are sort of the federal requirements, and you may have separate state requirements as well. I know, for example, in Michigan, that their Department of Transportation is also involved, because I have one client now where they did an FAA study, and they notified the Michigan Department of Transportation as part of that, and we got a letter from the Michigan Department of Transportation saying that they needed to get a permit from them under their process. So there are certain, obviously, state reviews as well that you would need to look at.
All right, the next one is, do you have to replace existing red lights, existing red side lights on a tower and make them flashing lights?
Okay, so I think, this was going back to the new advisory circular that came out in December. Let's see. Okay, the last point here, I believe that we were talking about where for some types of structures, they want you, or it's taller than 50 feet, they want you to use only flashing lights, or for, depending on the height, they want you to use the flashing lights, the side lights. So these requirements, you don't have to go back and change anything that's already been approved on an existing tower. These are new requirements that apply on a going forward basis to new towers. But anytime you make a change to an existing tower, the FAA will likely require you to, at that point, go and change the lighting to meet these new requirements. So the third bullet point on this slide is effective immediately, and then the second one for towers that are under 350 feet, that will go into effect in September of this year. But for all of these, again, it only applies on a going forward basis, so you don't have to go back and make changes.
Existing towers are grandfathered. It's only if you make changes that some of these things will be activated, or for new towers.
Correct. Yeah. Yes.
Okay.
All right, and then the next question is, somebody asked where the full text of the 6409 Spectrum Act can be found.
Well, I mean, I think that maybe if Steve has not already...
It's actually part of the Middle Class Tax Relief Act of 2012. The Spectrum Act is a part of it, and it includes things like the broadcast incentive auction that is getting going. It has things to do with white space. It has things to do with FirstNet. So there's a lot of stuff in it. This was, historically speaking, one of the things that Congress wrote into the early draft, and it never really changed, and we didn't have to do any lobbying on it because we kind of liked that they used things like wireless facilities as opposed to mobile wireless facilities, and we liked some of the broad language that was in there, and it stayed there, and then the FCC put out an advisory shortly after it was adopted, and then went through a rulemaking proceeding. So if you're looking for it, look for it in the Middle Class Tax Relief Act of 2012.
All right. Next question. Under the 20-foot exemption for FAA review, does that include, for example, an antenna mounted on a 6-foot pole on an existing building roof, and it's exempt?
So again, with the caveat that you need to look at each thing on a case-by-case basis. But so generally, if you are putting up an antenna onto an existing building and that you are not going more than 20 feet in height above that building, generally that is exempt under this requirement because you're not increasing the height of another antenna structure. So that's generally how that's been applied. But again, I think you would need to look at it, on a specific case-by-case situation to see if what you are doing, meets that exemption. So it's possible, depending on what type of structures you have on top of the building. In some cases, there is towers and things like that. But so generally, if it's like I said, if it's a building and you're not going more than 20 feet above that, typically you fall within that exemption.
All right. And looks like the last question we got on the list. Question is, so any towers that have RF need up-to-date signs warning of the potential RF hazard?
I'd say generally yes, that's true. Like I said, we could have done a whole presentation on the RF requirements in general, but typically yes. And that's the FCC's rules impose these obligations on licensees to make sure they're in compliance. So typically these are in the leases where the tower owners will require the licensee who's going on the tower to make sure that they are in compliance with the RF and that rules, and that any necessary signs are put up on there. But again, the type of signage you might need depends on whether or not you're within the general limits or the occupational limits, who has access to the site. That could affect what type of signage you might need up on the structure. But typically, yes, anytime you've got licensed facilities and it's possible that somebody might be exposed to that RF radiation, where they would be in excess of the limit, it will need to have some type of signage up on there that alerts them to that.
One of the things about RF is the rules, talk about reasonable signage, and there were a couple of FCC commissioners who kind of felt like Sprint and T-Mobile could have been entered into the consent decree because the FCC doesn't really have rules beyond what somebody might think is reasonable and other people might think is unreasonable, and so they sort of criticized the FCC for taking that tack. But it maybe signals that there's a reason to kind of put, as Kevin was saying, conduct a rulemaking proceeding, so we're not out there in the uncertainty of what's reasonable and what's not.
Yeah, and in that rulemaking proceeding, the FCC has proposed specific types of signage and other things that you would need to do at the site, depending on whether you're over the general limit or whether you're over the occupational limit, and depending on what types of transmitters you have and what equipment you're using. So hopefully that proceeding will provide some specific guidance to companies that will make it easier to comply.
All right. Well, I want to thank everybody who attended this webinar. Great questions, a lot of good information. Also want to thank Steve Cran and Kevin Kukler from Lerman Center for putting this webinar together for our members. I think it has a lot of value and opened up my eyes about some things that I may have to rethink about one of my towers. Again, I'm going to go ahead and make this recording available and send an email out to the members list with the information of where you can get it for those who want to review the webinar again and for those who were unable to attend.
Hey, one last thing, Alex, and that is that we're going to be doing a session at WISPA America next month on tower regulations, and Kevin has agreed to go to Louisville, so some of this material and some more questions you'll be able to ask at that time, and Kevin will be around to sort of so you guys can put a face with a name. There's a shameless plug.
Okay, great. Well, I will see you guys later, and again, thanks again to everybody. We'll talk later. Bye.
Thank you. All right.